So we are going to begin.
Thank you, Chair. I'm pleased to be speaking today as a representative of the Canadian Teachers Federation, an organization comprised of teachers' unions in every province and territory. I am a teacher with over 20 years of experience in the classroom. I would like to acknowledge that I work and play on the unceded territory of the Algonquin Anishinaabe people. As you know, I'm here to talk about Bill C-273, a bill that seeks to repeal Section 43 of the Criminal Code. With this, I need to state first and foremost that the Federation fully endorses all TRC calls to action, including action number 6. We also fully condemn any form of corporal punishment. That being said, the Federation cannot support this legislation passing unamended. The risk of unintended consequences that could make classrooms more unsafe is too great. Teachers need to be able to physically intervene in certain classroom situations. This is the reality of dealing with complex classrooms with complex needs. And I'm sharing my time today with teacher colleague Tisa Fiddler. Tisa is a member of the Federation's Advisory Committee on Indigenous Education, and she's also a member of Education's International Indigenous Reference Group. So I'm really pleased to present Tisa.
Thank you. No, that's good. Thank you. I forgot that step. So, Tisa Fiddler, Indigenous. I am a First Nations educator, registered to Kitchinimegazib and Inuag in Treaty 9. I'm also connected through my father to the traditional territory of Onegaming First Nation in Treaty 3. My family and I have lived and worked in Thunder Bay, Ontario for the last 26 years, and we raise our family there. So first, I as well would like to acknowledge that I'm grateful to the Anishinaabe and Algonquin people whose land I'm visiting here for being caretakers of this territory since time immemorial, for allowing us to do this work here. As an Indigenous educator with close to 30 years, I couldn't believe that when I read that, I'm like 30 years of experience, and as someone who is deeply committed to supporting the act of reconciliation, I'm here to speak about the necessity of amending Bill C-273. I want to assure the committee and other individuals who are committed to repealing Section 43 that I also recognize the significance and the importance of making this important change to the criminal code. I personally honor and respect the calls to action. As a second-generation survivor of residential school, my mother attended Poplar Hill, and my father attended Cecilia Jeffrey. The calls to action have significance to me both personally and professionally. As a witness to violence myself, I would never condone any form of violence in homes, classrooms, or other institutions. I have the utmost of respect for Honourable Sinclair and the many individuals who courageously led the TRC and provided this country a guide to improving relations between Indigenous and non-Indigenous peoples. I am not here to disagree with the repeal of Section 43. I am here to request that you consider the suggestions that teaching experts bring forward, suggestions that will continue to protect students and their educators. Over my career, I've worked with students who have complex needs, and I've been a mentor to many teachers and educators who deal with complex classroom issues. We have students with autism and FASD, students with problems regulating temper, students with histories of violence and exposure to trauma. In an ideal world, there would be more support for students in difficult situations, and educators would get the support we need to deal with these complex student profiles and situations in classroom. The sad reality is it is not there. So passing Bill C-273 without an amendment will make an already challenging job more challenging. These are the realities that all educators, but also Indigenous educators, are facing. We have very complex community situations right now. We are in crisis with our, well-being of our children. And as a parent of a child with complex special needs, I recognize the challenges that our communities and our families are facing. And it really is a disadvantage to children, to educators, to put this bill, or to repeal this act and not be making the amendments and suggestions that are needed to protect children.
Thank you very
Miigwech.
much
Thank you.
for your opening remarks. We will now go with Monsieur le Directeur Général.
Merci.
Thank you very much. My name is Sébastien Joly, Director of the Quebec Provincial Association of Teachers. We represent the 8,000 teachers who work in Quebec's English language public system. The QPAT is also a member of the Canadian Teachers Federation and negotiates in cartel with the Fédération des syndicats de l'enseignement du Québec. I'd like to begin by thanking you, the members of the committee, for allowing me to present Quebec's perspective and the reality of the teachers we represent in the context of the study of Bill C-273, which deals with the repeal of Section 43 of the Canadian Criminal Code. From the outset, the repeal of Section 43 without amendment is a major source of concern for our association. Knowing that this bill stems from the 94 recommendations of the Truth and Reconciliation Commission and the related calls to action, it is essential for me to clarify that the position adopted by the QPAT is in no way intended to minimize the abuse suffered over years by the Indigenous peoples of Canada in residential schools, nor to question the highly symbolic value of the removal of Section 43 of the Canadian Criminal Code, a symbol of the past practice of corporal punishment, both in educational institutions and households. To the contrary, the Association fully subscribes to the spirit of the measures recommended by the Commission and has been actively involved, in particular, in the curriculum review process in connection with calls to Action 62 and 63, Education for Reconciliation, that led to the review of the content of the History and Citizenship Education program in Quebec. Furthermore, the QPAT has been opposed to any corporal punishment. I'm now going to switch into English.
While we are fully aware of the intent behind the introduction of this bill, it is essential to ensure that its adoption does not result in unintended and unfortunate consequences for the teachers we represent. In this sense, we are convinced, following the advice of our legal experts, that the removal of the elements of protection included in Section 43, in the absence of an amendment to the Criminal Code to guarantee protections for school staff, would constitute a serious risk for teachers as well as for other categories of school staff, particularly given the context and conditions in which they practice their profession on a daily basis. Indeed, the increasingly heavy and complex composition of the classrooms in the context of glaring lack of professional and specialized support resources, as well as the constant progression of violence in our schools, whether in or out of class, means that teachers are confronted on a regular basis with situations that could require the use of reasonable force towards a student with the sole objective of fulfilling their responsibility to ensure a safe school environment for the students. The legal vacuum thus created would necessarily expose them to an increased risk of criminal charges, prosecution, or even convictions for interventions carried out in the course of their duties. These interventions would automatically be considered assault under Section 265.1 of the Canadian Criminal Code. As Executive Director of QPAT, I am directly responsible for following up on all cases related to criminal allegations filed against teachers who are members of our local unions throughout Quebec, working closely with the law firm Batista Turco Israel from Montreal, who represent our members in such cases. As such, I can confirm that the existence of Section 43, the scope of which was significantly redefined by the 2004 Supreme Court's decision, can no longer be used as a defense for teachers charged with assault within the meaning of the law. Nevertheless, I can confirm that it is the very existence of Section 43 that allows the various stakeholders involved, police investigators, prosecutors, judges, to exercise a certain level of discretion in such cases, particularly when it is clear, following investigation, that an educator used reasonable force with the purpose of ensuring safe school environment for their students. As a result, many cases do not proceed to trial. According to our legal experts, the complete repeal of Article 43 would result in the disappearance of this level of discretion and in an increase in the number of charges, prosecutions, and convictions, with all the impacts that this implies for the individuals concerned and their families. Finally, we are also concerned that this increased risk for teachers could cause additional unfortunate and unintended consequences, including making our schools less safe, but also discouraging potential future teachers from choosing this beautiful profession and making a career out of it, thereby further exacerbating the teacher recruitment and retention crisis facing our public school systems in Quebec and across the country. It will be my pleasure to answer any questions you might have and develop more on the elements presented in the brief submitted by QPAT. Thank you. Merci.
Merci à vous. Merci beaucoup.
Thank you. Thank you very much. We are going to begin a first round.
We'll go to Mr. Frank Caputo.
Thank you very much. I want to thank all the witnesses for being here. It's a pleasure and honor to be with you, in part because I have a child who is neurodiverse, and my sisters are both teachers, and I practiced and taught criminal law for a number of years, so it feels like the intersection of those three things coming together. So I thank you for the discussion and for your presence here. I think that goes without saying that everybody here, including the panel, denounces any form of abuse. The question is how should the law properly respond to what is necessary, I suppose I could be using your words, for a safe school environment, and that's where I take your positions. Now, in your opening statements, you didn't really get into we got into the broad strokes, so I'm not sure if on behalf of both organizations, if you could point specifically to the frailties of the removal of Section 43, what would those be from your experience, please?
Want me to start?
Both organizations.
So, as I said in my opening statement, I've taught for over 20 years, 23 years, and I remember my first job, I was in a pré-secondaire, which is a grade 7 class. I was brand new. You know, when you're a new teacher, you do your best. And a fight broke out in my class. Luckily, they were smaller than me. They were in grade 7, they were 12 years old. And it was quite the fight because there was blood drawn. And I pulled those two children apart. And one I took with me to the principal's office. According to the criminal code, that could be assault. And of course, I did my duty because I wanted to protect the kids that were in the fight, and I wanted to protect the children that were in the class. I could have been charged with assault for doing what I did. I didn't know. I was new. I didn't even hear of Section 43. So this is our fear, is that by not amending Section 43, we put teachers at risk of being charged with assault. In our brief, there's about 50 examples of incidences where Section 43 was called upon, and they didn't go to court, those cases. Some of them did. There's one recently in 2023, Bender versus Ontario, that went to court, and that teacher was dismissed. But this is what we fear. And another thing that we fear is, personally, as a union leader, I would be telling teachers, be very careful. Do not put your hands on children. There is nothing to protect you in the criminal law.
If I may add, essentially to your question, we in Quebec have the same concerns regarding the repeal of Section 43. With our experience in Quebec and the experience of the Quebec Provincial Association of Teachers regarding allegations of criminal nature that were filed over the years against teachers, and it has been confirmed by our legal counsel we work with on all those cases, that Section 43, although, because we've been asked how many cases have been, or how many court decisions have been mentioning Section 43 as a defense for a teacher or an education worker, there's not that many. And because there's a reason for that, the majority of cases do not go to trial. I was a witness to one case where we went to trial. We were before the judge representing our member, and the judge from the get-go, I think it was a junior prosecutor who probably was not really aware of the existence of Section 43, and basically the judge right away took a decision on the bench. It's not documented. Because he was actually reminding the prosecutor of the existence of Section 43. So it's very important to understand that probably 90 to 95% of the cases where there are allegations, Section 43 is considered by the different stakeholders before it goes to trial. And obviously, from experience too, there are allegations on a regular basis towards teachers for various reasons, including assault or alleged assault. And it takes a big toll on these teachers and their families. Even for investigation to be completed, often of time we're looking at 1 to 1.5 years, before the investigation is completed, and that's even before the prosecutor is looking at the case. So the teachers are suspended for a good amount of time. And certainly we have exactly the same concerns that we will multiply the number of allegations and accusations, and maybe more cases going to trial in the absence of Section 43.
Thank you. I appreciate your time because I know we probably don't have time to go through a lot more here, but to me, a teacher, and I'm thinking about my own child too, and needs that arise in order to protect them and protect others in those situations. I mean, the situation mentioned by Ms. Vietman there to separate people, to me, it's an unfortunate part of the job. I don't think anybody wakes up in the morning, a teacher wakes up in the morning saying, I want to do this, but I take your point, assault is a non-consensual touch, and no one's saying, please touch me there. So,
Merci. Thank you.
Thank you.
We will now move on to Mr. Housefather.
Thank you, Madam Chair, and thank you so much to Ms. Yetman and Mr. Joly, and both of your organizations are very important to me. My mom was a school administrator. Both of my aunts were school administrators. So I've heard directly several times about the consequences of this bill and what they think about it. Can I ask one question, Mr. Joly? You made a very good point because there's been a lot of people that have raised, well, there's so few times that this needs to be used as a defense. What you're actually saying is that it's rarely needed to be used as a defense because prosecutors know that it's there and therefore are not charging people with allegations related to assault in the classroom. Would that be correct?
That's exactly what I was saying, because, again, I've been handling those cases since 2016, but the firm we're working with has been working with the association for more than 20 years. And certainly there was a big change since the 2004 Supreme Court decision that really, limited the scope or realigned the scope of Section 43. And certainly, in most cases, it doesn't go to trial. The charges are not deposited because of the existence of Section 43 as realigned by the 2004 Supreme Court decision. And again, in an ideal world, it would be possible for teachers not to intervene ever physically towards students who would have enough support staff and resources in order to deal with all situations. But in my brief, it's very clear, that statistics we have about violence in the classroom and the number of possible situations that teachers are faced with on a daily basis, particularly those who are teaching in specialized settings, we're talking daily. So obviously, it would be a big loss if there's no amendment to really provide protections for our teachers and education workers.
No, and I appreciate that. And I have one more question before I go to Ms. Yetman, Mr. Joly. One of the claims that has been made is that there are other professions that deal with children, a nurse's aide, a child care worker, that are not covered by this defense, and yet somehow there's not an extraordinary number of charges against them. Could you explain why you believe there needs to be a specific category protection for teachers?
Essentially, if you read my brief, you will see that I'm talking about education workers, also school staff, because obviously we're representing teachers, we're representing people who work in the education system, so we're not representing nurses. But in essence, the number of cases compared to the number of workers who work in the school system is not that great, but every single case, as far as we're concerned, counts. And we have enough per year just for the 8,000 teachers we represent, whereby Section 43 and the elements of protection included in that are considered to avoid these charges to being pressed against teachers for actually applying a reasonable force in a context where they're trying to ensure a safe school environment for their students.
Thank you. And Ms. Yetman, we had a chance to talk about this, and I like the example that you gave of your grade 7 class when you first started teaching. Can I add, you, as I understand it, your organization is not opposed to the repeal of Section 43. You simply want it to be replaced by a modified defense that would be more in line with contemporary values, correct?
Well, of course, Section 43, I think, was written in 1892, so we do need to update that. Of course, the 2004 Supreme Court decision was very helpful in adding guidelines. We believe in truth and reconciliation. We actually think that it's a shame that only 13 of those actions have happened so far out of 94. And so, yes, I think that it needs to be revised. It is too vague. It's not clear. And that's why we're suggesting an amendment. And the amendment would be called like a safe school amendment, really focusing in on safety.
100%. And can I ask, would you, and I've seen the amendment and I support the variation of this amendment, would you object if, for example, other professions that also dealt with children in a similar way were incorporated into the same wording that you proposed? For example, childcare workers, nurses, aides, etc.?
Now I'm speaking personally. I don't see a problem with that. I, of course, am representing teachers and education workers, so I wouldn't want to speak on their behalf. But I think we need to protect people that are working with children, that are doing things to keep them safe. That's what it's all about. It's about keeping children safe.
And making sure that there's not a teacher or other educator that wouldn't act in a situation where they needed to pull children apart like you did. Okay, thank you so much, Madam Chair. I see your hand is up. Thank you.
No, you have 20 seconds left.
Well, anyways, I want to just thank the witnesses for being here. I highly respect the organizations. Thank you.
Thank you very much. Alors, on passe maintenant.
We'll now move on to Mr. Fortin. Thank you very much, Madam Chair. I'll use those extra 20 seconds, if you don't mind. Ms. Fiddler, Ms. Yetman, and Mr. Joly, thank you very much for coming today. Now, I don't know if it was said at the beginning, but as you know, we do have interpretation services, so you can answer in the language of your choice, and we will all understand your testimony. So I'll leave that up to you. Now, I'm very happy to see you here today. This is a very important issue. It deals with our children and their safety and their education. And obviously, any violence towards children must be prevented. And as lawmakers, we have to make sure that violence is never authorized. Now, if we sort of look at the overview of the jurisprudence and what's happening in other areas, what strikes me is that corporal punishment is forbidden pretty much everywhere. But I'm wondering here if we're not mixing up a few things here, corporal punishment and the use of force in order to ensure the safety of our children and their education. That is to say, to protect them and to protect their environment, whether it has to do with classmates or other people. So this is the concern I have here when we're talking about C-273. I've been very interested in hearing what you have to say, because it kind of runs along the lines of what I've been thinking since the very beginning. But I would like to hear you on this. Mr. Housefather said could it not be useful to provide an exception for other people, health workers, for example, working with children? So how far should we go? Should we sort of put some of these workers on an equal footing and make these changes? In other words, anyone who has the authority of a parent or delegated authority, for example, whether that be a teacher, another parent, for example, do you think these should be included? So could you just expand on that, perhaps Monsieur Joly first and then the others? Well, once again, I am a parent as well. So as a parent and also as the representative of teachers, I would say that I'm speaking on behalf of these teachers and other educational workers. Mr. Housefather was asking if we could include, for example, all people who are involved with children, whether it be educators or whether it be in daycares or elsewhere. We wouldn't be opposed to that. However, what we're talking about today is the teachers and the teaching environment and our concerns about the consequences of a repeal without amendment of Section 43. Consequences on their daily work and on their exposure to potential problems because of the work environment, because they are already exposed to these issues. And what about parents? Well, as I said, as a parent, I could say, personally, I wouldn't oppose that. Obviously, there are groups of parents who will be able to speak to you. But I would say, personally, that sounds reasonable to me to include parents. However, once again, I do represent the teachers here today. So I'm just trying to be diplomatic here. Thank you very much, Mr. Joly. Ms. Yatman. Well, I'll probably answer along the same veins. I also am a parent of 2 boys, and I remember at times I've had to make them put on their boots and hold them to make them do that. So personally, I wouldn't say that I would be opposed to an amendment that could help the public in general, including parents. However, today I am here on behalf of teachers, and so I have to be the voice of teachers today. Thank you very much. You're all doing that very well. However, I'm asking you the question because you are the experts, in a way, on education, the education of children, and this is going to impact all those who are involved in the area of education, whether it be those who are looking after them or those who are teaching them. So all these people who are involved in children, and so should they not all be treated in the same way? And should we not ensure that all those can intervene when they need to, when they are responsible for these children in one form or another? I don't know how much time I have left. Time goes by very quickly, but I'd just like to raise something else quickly. Bill 273 actually stems from or is aligned with the calls for action under the Truth and Reconciliation Committee. You mentioned it yourself. And I'd like to know if you have an opinion, perhaps you don't, but if you'd like to have an opinion on how the repeal of Section 43 from the Criminal Code would help advance the issues that Indigenous communities are dealing with. Now, we know that there has been abuse in the past. None of us find that unacceptable. But what would the repeal of Section 43 do to advance Indigenous communities in this country?
The repeal of Section 43 would just honor, I think, the history, honor the history and the truth that came out of the history. And that history has caused a legacy of ongoing violence and harm. And so those were the recommendations that came out of that. Now, we could probably go back now to community. This is, 8 years later, and start asking, what do we need next? And that is to put in those safeguards that will protect children and families and the organizations that are providing a service to a very vulnerable population. So I think that is what the repeal would do for our communities.
Merci à vous trois.
Thank you, Gretch.
Thank you to all 3 of you.
Pour le record,
Just for the record, I did give you more than 20 seconds extra.
On pass for
We're now going to move on to Mr.
6 minutes.
Thank you very much, Madam Chair, and I thank the witnesses for being here today. And I do recognize that you're doing a job of representing your members, but I have some questions which are not hostile, but I have some concerns. And I guess I'll talk about the 94 calls to action. Were either of your organizations involved with the Truth and Reconciliation Commission at the time of the hearings?
I have only been present since July of 2023, but we work very closely with our advisory committee. So, and I don't know if Tisa, you were involved at that time, so I really can't answer that.
We were not involved in an association in the commission, in the workings of the commission, but we did take steps even before the end of the work done by the commission since early 2000s in order to push the government of Quebec to review education programs, namely history programs. I'm a history teacher. As a union representative, I've been pushing that for quite a while with, some success. Not perfect, but certainly there were changes made in the content on Action 62 and 63 particularly. We were involved actively.
And if I'm not mistaken, I believe both your organizations did endorse the calls to action at some point.
Yeah, that is correct. And we have done a lot of work in trying to get the calls to action for education moved forward in the provinces.
Sorry if I could just answer. So I've been with the Canadian Teachers Federation on the Advisory Committee for Indigenous Education. This is my 5th year with the organization, and I worked provincially with the Ontario English Catholic Teachers Association for about 8 years, I guess 7 years. It was shortly after the calls to action were published. I've been part of the revisions to the Ontario curriculum. I've been on the writing teams. But personally, I gave testimony at the Truth and Reconciliation Commission. I've worked very closely with many folks that have been part of the TRC. My husband worked with the Truth and Reconciliation Commission and traveled across the country. So the advisory committee brings that depth of knowledge and guidance to the work of the Canadian Teachers Federation.
And I'm asking that question of both of you because I think there's both a real substantive problem and a perceptual problem if non-Indigenous organizations are substituting their judgment for the Indigenous community on this section. So what I was trying to do is give you a chance to express your support. Has there been any communication with Murray Sinclair or the other commissioners about these concerns with the repeal of this section?
Well, I do know that the Canadian Teachers Federation did meet with Sinclair. This was before my time. And we have spoken to him about this particular action.
Because I do think that's an important part of the reconciliation process is to continue that dialogue. Mr. Joly.
And I've been part of meetings back in 2018 with a group of senators that had taken on, this action, basically, and to raise the same concerns. Met with 5 senators at the time. And then it fell on the wayside, and then it's picked up again. But certainly, we express the same concerns with the complete repeal of 43 without any amendments.
Go ahead.
Sorry, just to renew the new term of this committee for the Indigenous Advisory. We've reached out to reestablish and to maintain relationship with the National Centre for Truth and Reconciliation as well. With COVID, there was the pause, but we're actively doing that work to engage the NCTR and continue supporting the good work and important work they do.
Thank you for anticipating my next question. We have some other technical problems, I think, given that we're dealing with a private member's bill before us. So I do not in any way doubt the challenges that teachers are facing in the classroom at this time. And I'm not at all one to diminish the concerns about the legal consequences of the repeal. But 2 things I would raise here. One is that education is primarily a provincial jurisdiction, and therefore I'm not sure outside the criminal code we can deal with some of the major problems. And the second is, of course, that this bill deals with repeal, and private members' bills have a certain scope by the rules of the House, and trying to amend either other sections of criminal code or other acts may be difficult and may, in fact, be out of order. And I just wonder if you have any reaction to those concerns.
Well, from when we consulted our legal counsel, certainly this issue was raised, the technical issue of how do you bring about an amendment. And from our understanding, and maybe we're wrong, but from our understanding, it would be possible that the committee increases the scope of the bill. And if not, is it possible to actually make an amendment to the criminal code at a different time? But again, it would be ideal for us that it would be attached to this bill, that there would be a guarantee of ensuring protections for education workers and teachers within the bill.
Yes, and of course, I'm a teacher. I'm not a legal...
Time's up, but I would like to hear the answer
I'm not a
to that.
legal connoisseur, and I don't know the procedures in legislation, but we are counting on all of you here in the room to help us with that so that we can make sure that students are safe in classes.
Thank you very much. We will now go to our second round, and for 5 minutes to Marilyn Gladue.
Thank you, Chair, and thank you to the witnesses for being here. I come from a family of teachers. My mother was a teacher, and my daughter teaches now on Six Nations. So I'm very happy to hear your comments today. One of the discussions that we've had in the testimonies we've heard so far is that we've clarified that it's already illegal to abuse a child or to do violence to a child. And certainly, I think the Supreme Court decision, as Mr. Joly mentioned, with their interpretation, they added that the use of force must be sober and reasoned, address actual behavior, and be intended to restrain, control, or express symbolic disapproval. They also noted the child must have the capacity to understand and benefit from the correction, which means Section 43 doesn't justify force against children under the age of 2 or those with certain disabilities. And according to the decision, reasonableness further implies that force may not be administered to teenagers, as this can induce aggressive or antisocial behavior. And moreover, force may not involve objects such as rulers or belts and may not be applied to the head. So I think that, we've heard from you today that there are not that many complaints being brought forward, and because people understand the protections under Section 43. And so my question then is, do you think that Section 43 as written does provide you needed protection today? We'll start with Mr. Joly.
Yes, it does, as written, but also as realigned or modified with the Supreme Court decision from 2004. And it is the opinion of our legal expert that if it's repealed completely without any amendment or any form, like, again, technically, I don't know how to do this, but maybe you know, but it would pose a risk, and it would change the game when it comes to these kinds of allegations. And again, when I was saying that Section 43 is always considered by stakeholders who are involved, investigators and whatnot, and it's always after the investigation has been completed and the conclusion of the investigation shows that, it was use of reasonable force as per the definition, and also it was meant to provide protections or to ensure safety in the school environment. And that's where the stakeholders can use their discretion. That's where the police usually will say to the prosecutor, we would not recommend that you proceed with charges. The prosecutor will move ahead with this and not proceed with charges. And that's where it has an impact in 95% of the cases.
Thank you. And same question, Ms. Yetman.
Yes, right now it is protecting teachers. There was a judgment in December 2023, the Ontario Court versus Bender, an elementary teacher, who was teaching grade 3. He was teaching a difficult class of students with special needs, and the conclusion was that unfortunately, what happened was he was charged in December of 2020. It took 3 years before the judgment came out, and the conclusion was his actions were justified under Section 43. So yes, it is doing the job. Now, as I said before, it was written in 1892, and I think the problem with Section 43 is force by way of correction. And that's why our amendment is really precise about safety.
Further to that, I think Mr. Garrison is actually correct that we're not allowed to expand the scope of the private members bill. And with that in mind, then to me, keeping 43 as it is, and knowing that the courts are going to interpret not just Section 43, but also the Supreme Court's judgment upon that is going to be important. Now, is there anything else that you would like to tell us in terms of expanding this, the scope of who it covers? I know we've heard Mr. Housefather on including other people. I heard you clearly say parents, teachers, but you're not opposed. Is that fair? Mr. Joly.
Again, we're representing teachers.
All right, and same comment from Ms. Yetman. Okay, thank you so much for your answers.
Thank you very much. We will now move to Madame Dillon for 5 minutes, s'il vous plaît.
Thank you to our witnesses for being here and the important work you're doing. I'd like to start with, a comment. Section 43 doesn't apply currently to nurses, childcare workers, or other professionals who deal with children regularly, and they may need to use force to ensure a child's safety. These individuals are not disproportionately sued for using force. We're talking about reasonable versus unreasonable force. Why do you expect that teachers and parents are going to be unfairly treated if these other professionals are not? Thank you.
You okay? So, first of all, since the pandemic, I think it's really important to note that violence in the classroom has gone up. The Elementary Teachers Federation did a member survey in 2023, a year ago, and 80% of their members said that the number of violent incidents has increased. And teachers will experience an upward of 50 instances of harassment or violence over the course of 1 year. So, and I'd also want to just mention, which may not, might be a little bit outside, widening up about a bit, 80% of teachers are women. And I think that's important as well, because it means that women are working in very unsafe environments. And what we're seeing, because as Tisa mentioned, we don't have the resources, there's systemic underfunding of education in provinces. We need more training, we need more resources, and since that doesn't exist, if Section 43 disappears, we're going to see, as we've said before, we're going to see more problems of violence because teachers will be reminded to not put their hands on children. So we're going to do more of these evacuations. I'm sure you've heard of these, where a child is having dysregulation, and we have to evacuate the entire class.
Well, as my colleague, Mr. Garrison, has pointed out, this part really falls under provincial jurisdiction. We're talking here about protecting children from unreasonable force. I'm very concerned as well in daycares. Children of 2, 3, 4 years old cannot express themselves, and they are subjected to abuse, a pinch on the upper arm, a tug to the hair, and things like that. And it comes in the news, and it's sometimes horrific stories. How do we protect those children who are not able to express themselves? If you can please elaborate on that. And how come, there should be an exception in the criminal code for the use of force to correct children's behavior when we don't have such an exemption for any other class of people?
again, the exception or the amendment we're asking for is for the sole purpose of ensuring safety, a safe environment in a school setting. It's not to allow teachers to use force to correct students. And by the way, Section 43 no longer, if there's a situation where unjustifiably and not to ensure safety, a teacher or an education worker, educator in a daycare center would use force to correct a student, it's unlikely that Section 43 would protect them currently with the 2004 realignment by the Supreme Court decision. So essentially what we're demanding about the amendment is really to ensure that those protections for the safety of the school students be maintained or be placed somewhere else in the criminal code, because in the absence of this, and it's our legal experts' opinion that we should advise our members not to get involved physically under any circumstances, because of the risk of possible allegations and charges.
And as our witness, Ms. Yetman, has pointed out, most teachers are female. My mother was a teacher. Her 4 sisters were teachers, and so I come from a family of educators. And if you can quickly tell us what other tools could be available to protect these female teachers, other than having to change this legislation, which is really the aim to protect children. Thank you so much.
Yeah.
This is going to sound crazy, but we need resources. Well, it's not that crazy, actually. It's been years and years that our school systems have been underfunded.
So I'm going to have to interrupt now just to allow the 2 remaining to answer questions. Alors, Monsieur Fortin, pour 2 minutes et demie, s'il vous plaît.
Mr. Fortin, you have 2.5 minutes. Thank you very much, Madam Chair. Now, we've heard that repealing Section 43 could potentially lead in an increase in the number of charges brought against teachers. Our committee has heard testimony on provisions of the criminal code that deal with underrepresented groups in our society. And I'm wondering what effect there would be on other underrepresented groups if Section 43 were to be repealed. Let's say, for example, Indigenous parents, or whether it be racialized parents or parents of racialized children. Would repealing Section 43 have an impact on those groups? And if so, what would that impact be? Well, I'm not sure that I'm able to answer that question, but the protections under Section 43 also apply to parents. Now, I only have 2 minutes, so if you don't actually know, then perhaps we'll move on to Ms. Yetman or Ms. Fiddler.
Yes, so just the impact that it would have on underrepresented groups. So I can speak as an Anishinaabe person, and what I've witnessed and what I've experienced as well. And there is a lot of, because of the history and the trauma that we've experienced, there's been a lot of family and community breakdown, and the systems that have traditionally been in place no longer exist. And so there's a lot of intergenerational parenting that is happening. Example, my mother is raising her great-granddaughter, her 9-year-old great-granddaughter, because my nieces are struggling with their own mental health and addiction issues. And so when there is that intergenerational parenting happening and biological parents might be absent, there is right there the optics of what is considered healthy parenting or healthy family systems. And, those are determined. We think about child welfare, what is an imminent risk. Those have been created by Western systems. So even though we are doing our best to maintain and preserve family, it isn't happening. But we're doing the best we can. We know that we're only 4% of the population, are Indigenous people in Canada, but 30 to 50% of our jails are Indigenous people. It's disproportionate, incredibly, and we could say the same for Black people as well, very disproportionate in its ratio. And so it would definitely have negative consequences.
Thank you. Merci beaucoup.
Merci.
For the last 2.5 minutes to Mr. Garrison, please.
Thank you very much, Madam Chair. So in the spirit of getting to yes and making sure there's no misunderstanding, I've listened carefully to what you had to say, and I believe both your organizations are saying that, in fact, you do support repeal of the existing provision, but that you need additional protections for teachers. Is that going to happen? Is that correct?
Absolutely.
Okay, so then that presents us with a challenge as a committee. And I appreciate that you've made suggestions for those changes that need to be added. And I remain concerned, as Ms. Gladue pointed out, we can't actually expand scope in a committee. Only the House can do that. And it's very rare that it happens. However, there are some ways in which we could get to the amendment. One is, of course, the government can at any time introduce legislation. So if this private member is moving forward, the government could introduce companion legislation that would make the changes that you're talking about, or another member could introduce an additional private member's bill, although that process is, of course, longer. So maybe I'll just, as we're running out of time, I don't believe the Canadian Teachers Federation, I don't believe Ms. Yetman has had a chance to talk about specifically what kind of changes that you're looking for in other sections of the criminal code. I know you've sent us material on this.
So our legal counsel has drafted an amendment that would be under 265.5. However, as I said before, I'm a teacher. I'm not a legislator, so I don't know where we go from here. Yesterday I was doing a little bit of preparing for today, and I noticed that, and it might be something that this committee can look at, New Zealand did an amendment in 2007 on their Criminal Act, and it was very similar language to Canadian's language. It was a force using correction that was changed to something different. So it was a repeal and an amendment at the same time, and the amendment was about safety of children. So that might be something to look at. That was done in 2007. So our amendment is in our brief, but it's basically to protect the safety of the child or to prevent the child from causing bodily or emotional harm to themselves or to other persons. So there is nothing here about corrective force. It's about protecting the child and making sure that they're safe. And hopefully everybody in the committee has received the document. If not, we'll make sure that you do receive that document.
Thank you very much. We have the documents, Mr. Clerk.
I'll just check if it has been translated.
We're going to confirm that it was received, or we have both the translation of them, because they don't send them out until and unless they're in both official languages. So with that, just want to remind you, if you've heard anything today or you've been asked any questions that you were unable to respond to due to time constraints, we would be happy to receive anything in writing. Unfortunately, our due date is what we've decided is tomorrow at about noontime, because we are going to meet again on Thursday morning to sort of see where the committee comes up with this legislation. So with those words, I thank you again for appearing. Merci beaucoup pour
Thank you very much to our witnesses this morning.
Week. Merci beaucoup. We will wait for a minute. We have some witnesses that are appearing in person, and I believe we have one by video conference, so we will do the testing to make sure everything works. Nous avons parmi nous
Welcome back to our second hour.
and panel. As individuals, we have Dr. Lisa M. Kelly. Is she there? Madame Kelly, can you? Okay, fabulous. Associate Professor, Faculty of Law, Queen's University. Mr. Marc Levasseur, individually, and representing the Nova Scotia Teachers Union, President Ryan Lutz, who actually comes from my Halifax West constituency as well. So welcome to all of you. You have 5 minutes each to present your opening remarks. And again, I think some of you have noticed, I will give a 30-second kind of look, and then because there are 3 witnesses today, I will probably interrupt at the time is up to allow the members on the committee to have sufficient time to also ask questions. And if there's any questions that get posed to you that you don't have sufficient time to respond to, that you'd like to send us a written message back, please do through the clerk's office. So we will begin now with 5 minutes each to Dr. Lisa Kelly, please.
Good afternoon. Thank you for the opportunity to speak with you today. My research and teaching at Queen's University Faculty of Law focuses on how the legal system affects young people as victims and as persons charged with criminal offenses, as well as their families and their teachers. At the outset, as previous witnesses have stated, I wish to state clearly that I share the goals of the sponsors of this bill, that is to end the practice of the physical punishment of children and to promote their best care at home and in schools. That said, the question before Parliament is a specific one about the role of the law, and in particular the criminal law, in this area. And I wish to focus on 3 points in my opening comments. First, the TRC's recommendation. Second, the potential legal effects of repeal for families and children. And third, the demographics of parents and guardians most likely to be affected by repeal. As everyone is aware, the TRC, in its 6th call to action,